I think we're ready to resume. Mr. Drabble.
Shortly before lunch, we were looking at unison, and in particular the passage at EF 1754 through to 1756 in the judgment of Lord Reed under the heading, "Does the fees order effectively prevent access to justice?" We looked at paragraphs 91 and 92. The other substantial passage that I rely on when read together with the later passages dealing with statutory rights as opposed to access to justice. The substantial passage starts at 1755 in halfway through paragraph 93, where just at the top of the page and just below letter A, Lord Reed says the question whether fees effectively prevent access to justice must be decided according to the likely impact of fees on behaviour in the real world. Fees must therefore be affordable not in a theoretical sense, but in the sense they can reasonably be afforded, where households on low to middle incomes can only afford fees by sacrificing the ordinary and reasonable expenditure required to maintain what would generally be regarded as an acceptable standard of living. Fees cannot be regarded as affordable. Now that's the phrase that's picked up by both Mr. Justice Jay and by the Court of Appeal, Lord Justice David Richards in the Court of Appeal. So we have both courts finding that these fees for registration cannot be afforded by households on low to middle income within the sense in which Lord Reed is looking at affordability. Then in paragraph 94, the judgment goes on to examine the impact on low to middle income households, and comes to the conclusion at the end of paragraph 94, letter D, leaving aside the other difficulties the Lord Chancellor's argument discussed earlier. The fundamental problem is the assumption that the right of access to courts and tribunals can lawfully be made subject to impositions which low to middle income households can only meet by sacrificing ordinary and reasonable expenditure for substantial periods of time. I say the courts below have accepted that that test of non-affordability is met on the present facts. That's the approach, of course, to the fundamental constitutional right of access to the courts. In order to see how it applies in our context, one needs to go on to the much shorter passage at 1757, and we have paragraphs 103 and 104. And 103 says, as explained earlier, the lawfulness of the fees order is also challenged on the basis that it contravenes the rule that specific statutory rights are not to be cut down by subordinate legislation passed under the vires of a different act, JCWI. That case was concerned with subordinate legislation which deprived asylum seekers of income-related benefits if they appealed against the Home Secretary's refusal of their claim. The Court of Appeal found that if deprived of benefits, some asylum seekers with genuine claims would be driven by penury to forfeit them, either by leaving the country before their determination or through an inability to prosecute them effectively. That being so, the legislation was held to be unlawful. Lord Justice Simon Brown stated that these regulations, for some asylum seekers at least, must now be regarded as rendering those rights of appeal nugatory. And Lord Reed went on to say, in circumstances of the present case, this ground of appeal does not add anything to the ground based on the common law right of access to justice, insofar as the fees order has the practical effect of making it unaffordable for persons to exercise rights conferred on them by Parliament, or of rendering the bringing of claims to enforce such rights a futile or irrational exercise, it must be regarded as rendering those rights nugatory. Simply applying paragraph 104, on the approach of the courts below, the fee required in order to register their citizenship has the practical effect, as the courts below have found, of making it unaffordable for persons to exercise the rights conferred on them by Parliament. Obviously, is the fundamental construction issue I made submissions on this morning is relevant to the issue of whether there are rights conferred on them by Parliament in the shape of the provisions such as Section 1.4, but for the reasons I've given, there are such rights. And so the statement is that that position means that the rights are rendered nugatory. Frankly, even if one looks at it on a postponement basis, we've seen already the value of citizenship to children who are growing up. If the exercise of the rights is unaffordable because of the fee, those rights are rendered nugatory for the length of the postponement, and that's enough, frankly, in order for the principle in 104 to operate. Postponed for 5 years, the rights are nugatory for 5 years. And it's very important on all the evidence that was submitted, considered by the courts below, for children to have access to the benefits of citizenship on the timescale that Parliament intended. So that's what I want out of unison. The directly relevant passage is very short, it's 103 to 104. But it's there, and it's part of the ratio of the case as well. Now, that leaves two final ports of call in my submissions. The first is JCWI, and the second is how courts below dealt with this. JCWI starts at
Mr. Drabble, just before we go to
Yeah.
JCWI, I mean,
Yes.
you say it's part of the ratio. Is that consistent with the first sentence of section of paragraph 104?
Wait, let me just go back.
And that's page 1757, where it says that the ground of appeal doesn't add anything.
Well, it was a classic case of there being two alternative lines of reasoning, sort of both of which support the conclusion. I'm not going to go to the wall about it.
I just wanted to raise that with you, but you say
no. I understand that. I mean, my take on it, for what it's worth, is it's put very shortly in 103 and 104 because it comes to the same conclusion for fundamentally the same reasons on the issue of statutory rights on the fundamental constitutional grounds. But that does mean there are two separate lines of reasoning, both of which point to the same conclusion. It's the last sentence, I think it's of 104. You just in a way.
Well, thank you very much.
Anyway, the last sentence of 104, I completely, I mean, that's the submission of whether it's open or not. I don't think I don't need my saying anything more. So we go now to JCWI. Which the judgment starts at 155 EF 1551. The argument that was being put by Mr. Blake on behalf of JCWI is summarised internal page 290B, but that's EF 1566. And at letter B, the submission is summarised by Lord Justice Simon Brown as being specific statutory rights are not to be cut down by subordinate legislation passed under the vires of a different act. so much is clear. These asylum seekers' rights, in which Mr. Blake, are being gravely interfered with by the regulations. They should therefore be struck down, just as this court struck down a prison rule giving an unrestricted power to read, in certain circumstances, stop correspondence between a prisoner and his solicitor. And then the answer that Lord Justice Simon Brown gave starts at page 1568, just above B. Recognises that this is not on all fours with ex parte leach, that is, it's not itself a fundamental a breach of a fundamental constitutional right. But ends up a fairly important observation. The present challenge, I therefore acknowledge, involves carrying ex parte leach principle a step further, and this, moreover, in a field where Parliament has been closely involved in the making of the impugned regulations, which is parallel with Mr. James's submissions in the present case. I have nevertheless concluded that it is a step the court should take. Parliamentary sovereignty is not here in question. The regulations are subordinate legislation only. The Hammersmith approach cannot, in my judgment, avail the Secretary of State. It applies only once the court has determined that the regulations do not contravene the express or implied requirements of a statute, the very question here at issue. Parliament, for its part, has clearly demonstrated by the Act of 1993 a full commitment to the United Kingdom's Convention obligations. When the regulation-making power now contained in the Act of 1992 was first conferred, there's no question of asylum seekers being deprived of all benefit and therefore being rendered unable to pursue their claims. Although I reject Mr. Blake's argument that the legislative history of this power, including in particular an indication to Parliament in 1986 that the government was then intending to exercise it in continued support of asylum seekers, itself serves to limit its present scope. The fact that asylum seekers have hitherto enjoyed benefit payments appears to me not wholly irrelevant. After all, the Act of 1993 confers on asylum seekers fuller rights than they ever previously enjoyed, the right of appeal in particular. And yet these regulations for some asylum seekers must at least now be regarded as rendering these rights nugatory. Either that or the regulations necessarily contemplate for some a life so destitute that, to my mind, no civilized nation can tolerate it. And then at the foot of the page, he says, true, no obligation arises, it's just above letter H, no obligation arises under Article 24 of the Geneva Convention until asylum seekers are recognised as refugees. But that is not to say that up to that point their fundamental needs can properly be ignored. I do not accept that they can. Rather, I would hold it unlawful to alter the benefit regime so drastically as must inevitably not merely prejudice but on occasionally defeat the statutory right of asylum seekers to claim refugee status. If and when that status is recognised, refugees become entitled under Article 24 to benefit rights equivalent to nationals. Not for one moment would I suggest that prior to that time the rights are remote to say, only that some basic provision should be made. It talks about in the remainder of that paragraph about how that might be done. Now, well, Mr. Justice J summarised the nature of my reliance on that passage, and I'll take the court to it in a moment. But I do rely on the statement just above letter D that the Hammersmith approach, which is an approach to rationality, cannot, in my judgment, avail the Secretary of State, applies only when once the court has determined the regulations do not contravene the express or implied requirements of a statute, the very question here at issue. Well, that's the parallel to what we do say, that the fee regulations contravene the requirements of the BNA 1981, provisions such as section 1.4, by making it impossible or difficult to obtain the right that's guaranteed by section 104. Similarly, just below H, we do say that the making of the present fee regulations alter the scheme of the BNA 1981 in a way which must inevitably not merely prejudice, but on occasionally defeat the statutory right which we ascertain and submit exists within section 104. It doesn't matter that this is only a right to apply for asylum, essentially. It's to make an appeal that might lead to asylum. Here, it's a right to make an application that will lead to registration. But the concept of cutting down statutory rights applies in both circumstances. Prohibition, cutting down statutory rights applies in both circumstances. As I say, it's possible to go to judgment of Mr. Justice J at EF.
Sorry, Mr. Dubber, before doing that, before leaving this page,
yeah,
ex parte leach is recounted at the top of page 1568 as referring to basic rights, not to constitutional rights, but to basic rights. And the same is said at page 1566. So on a full reading of ex parte leach, are those rights, access to a lawyer, described as a constitutional right or not? Because there is a distinction. The Secretary of State wishes to draw a distinction as to the test, depending upon whether it's a constitutional right or a fundamental right or some other right that's granted by a statute.
Yes. Well, I suspect that the Secretary of State would describe the right of legal professional privilege protected by ex parte leach as a basic right or a constitutional right, such as unquestionably brings fully into play the principle of legality, the ex parte Sims approach. And I don't demur from that. But what I do say is that it's possible to discern from JCWI and its treatment in unison a principle that if a statute creates a right, you can't exercise subordinate legislation to defeat that right unless the subordinate legislation is authorized by clear words. That is the approach that's enshrined in JCWI and in unison, and in 103 and 104 of unison. So, as I say, to do further ports of call on this, first of all, just to see what Mr. Justice J said about these submissions at EF 176. And he court will see that in paragraph 66, Mr. Justice J has set out the passage from JCWI which I've just read, and then summarizes my submissions in paragraph 67. Mr. Drabble draws, I think, three propositions from these passages. First, the relevant power may not be exercised in a manner which renders statutory rights nugatory. The right in question does not have to be fundamental. Mr. Drabble glossed this slightly to the extent that the right in question must be important, reflecting the language of Lord Huffman in Banco. Secondly, the test is not as high as impossible of exercise, but prejudice and on occasion defeat. Thirdly, the statutory right of appeal, which is being frustrated, was not the same as refugee status itself, but the former could not be envisaged without reference to the latter. In my opinion, applicants to be registered under the relevant provisions of the BNA 1981 may well be in a stronger position because the registration provisions are easier to satisfy than refugee status, subject always to the objective criteria being met. So what he's saying there is it's true that this is only the fee only frustrates the ability to make the application, but provided you meet the criteria in section 1.4 or whatever provision it is you're talking about, the making of the application leads certainly to the grant of citizenship, as night follows day. That's a stronger position in terms of the relationship between the substantive right in question, citizenship, than was true on JCWI, where the issue is the ability to exercise what we all know to be a difficult and fraught right of appeal. The inability to appeal was enough to exercise the right of appeal was enough to engage the principle. And then 68 is in a way only a forensic point, but it's quite a powerful one. I would add that had the issue in JCWI been a requirement in the nature of a precondition, that the notice of appeal to the tribunal would be accompanied by an unaffordable fee, the Court of Appeal would surely have come to the same conclusion, effectively for the same reason. That thought, we say, is just directly applicable here. You've got a right to apply to be registered as a citizen. If you put an unaffordable fee on it, you cannot exercise the right. And then in 69, he sets out, Mr. Justice Jay sets out, page 176, the statement of Lord Reid about affordability at paragraph 91, summarises the evidence before the Supreme Court as being that a significant number of people who would otherwise have brought claims found them to be unaffordable, sets out test at 93, and then records my submissions. Mr. Drabble submitted that this criterion is directly applicable and that the evidence before me demonstrates that a sufficient number of child applicants find the registration fee unaffordable. He also points out that the Supreme Court expressly considered JCWI, although Lord Reid observes that it added nothing to the primary submission. My own observation about unison is I do not think it necessarily follows that in a case such as the present, which does not involve fundamental rights, the Secretary of State would be acting unlawfully unless each and every child applicant could afford the registration fee. However, I appreciate the force of the contention, even with a slightly different test, tailored to address important statutory rights. The claimants have demonstrated that a fee as high as £1,012 is unaffordable. That last submission, I repeat, both the courts, including in the present case, found the fees to be unaffordable and in breach of the approach of Lord Reid in unison, as applied to statutory rights. So those are the principal issues on unison and JCWI. As I think I said this morning, there's a slight gloss needed because the language of JCWI and indeed in unison talks about statutory rights contained in a different statute. But that's an unnecessary complication. And the court will recall that this matter was touched on by Lord Justice Singh in the present Court of Appeal case at paragraphs 119 to 123, which the court will find at pages 147 to 148 of the court volume, EF 147 to 148. And Court C, Lord Justice Singh says, in my view, I can't resist reading 119. If the matter was free from authority, I would see considerable force in the submissions made by Mr. Drabble on behalf of the respondents, but I agree the decision of this court in Williams is binding. In my view, it's important in this context not to become distracted by reference to the concept, to the language of fundamental or constitutional rights. These concepts are of greatest importance in their proper context. In the present case, while Mr. Drabble accepts there are no fundamental or constitutional rights at play, what is in play is a statutory right conferred by Parliament in primary legislation. In my view, that does potentially give rise to the principle of statutory construction illustrated by the decision of the majority of this court in JCWI. That decision was not referred to by this court in its judgment in Williams, although it was cited in argument. And there's a reference to 103 and 104 of Unison, which we've been looking at. Agrees that the ratio is binding, end of paragraph 120 of Williams is binding. And then 121. At first sight, the JCWI principle might be thought to be confined to cases in which there is subordinate legislation under different primary legislation from that which confers a statutory right which is said to be rendered nugatory. That is how the principle was formulated in that case, which in my view is simply because that was the context in which the issue arose there. I do not consider the principle is so limited. It may be a matter of chance whether secondary legislation is made under the same primary legislation or other legislation. What is crucial as a matter of principle, in my view, is that there is a hierarchy of legislation. The primary legislation is enacted by Parliament and is superior to secondary legislation, which is made by the executive pursuant to powers delegated to it by Parliament. If there is a conflict between primary legislation and secondary legislation, it is the latter which must give way. In the end, as Sir James Eadie submitted, the question is one of statutory construction. What is the will of Parliament in conferring the power to make secondary legislation? In answering that question, one has to read all the relevant legislation and consider it was the intention of Parliament that a statutory right, which it itself has conferred on a person, is capable of being rendered nugatory by secondary legislation made by the executive. The fact that the secondary legislation is made in exercise of powers conferred by the same primary legislation may be relevant in answering the question of principle and the statutory interpretation which arises. But in my view, it does not automatically mean JCWI principle has no scope to operate at all. I will stop there. We accept that fundamentally it's going to be an issue of statutory construction, but crucial issue of construction is the discernment of the true scheme of the BNA 1981 and the constitutional settlement involved in the creation of the concept of British citizenship for the first time, with all the various entitlements, including 1.4 that were referred to. And so, although it wasn't open to the Court of Appeal or to Lord Justice Sim, in this case, to differ from Williams, we say the court should differ from him. And I think my final submission is to ask the court to go back to Williams, which the court will find at EF 1765. And I've already shown the court paragraph 45. The structure of the principal passage dealing with the ultra-vires ground, which runs from paragraph 37 through to the end of the day 52, turns on analysis on Lord Justice Davis' view of the statutory scheme. Lordship and the ladies will see that the last sentence of paragraph 43, where the reference to Fewings and Padfield is countered by reference to the question of what Parliament is elected to do under this particular statutory scheme. And your Lordships and my ladies have my submission on what the statutory scheme read in its totality actually envisages.
Is the test of what is a statutory scheme any different from any other process of conventional statutory interpretation?
No. My submission is that those bullet points I gave your ladyship before lunch are absolutely conventional points about the construction of a statutory scheme. You look at the language of the provision that's in play, which is the language of section 1.4 and the use of entitlement. You can look at the travaux, if you want to call it that, the white paper, and the parliamentary material. You gain a sense of what is happening in the basic BNA, which is the enactment of a major constitutional settlement. And you decide what Parliament meant when it used the formula shall be entitled on the making of an application. And what the Parliament meant was an entitlement, not something that could be defeated 20 years on by a piece of subordinate legislation setting an unaffordable fee. Lady Rose has a question.
Yes, but I suppose, and just leaving aside the facts of this case, I suppose it could be said that Parliament chose not to interfere with the conditions of the application. It left those to the executive on the usual principles.
Well, it created, I mean, my answer to that is the one I'm going to give, I've given repeatedly. It created a right. It made it plain because it would inevitably follow that the right arose on the making of the application. Now, on the principles, I don't think I need the principles of JCWI unison, but even if we've got them, and in any event, on those principles, what you can't do, you, the executive, is what we're talking about, can't do is make conditions that prevent the right actually arising. That's subject to all sorts of difficult arguments about, is it for all claimants or only some, which Justice Jay was referring to in the passage we've just been looking at. But the basic idea that the scheme of the BNA 1981 depends upon the abolition of jus soli being supplemented by a series of statutory entitlements is unavoidable. And that's not a difficult question of statutory interpretation. The confusion is frankly in Williams. It's Lord Hodge's question.
I think Lady Rose had a question first. Am I right? Yes.
Yes. I'm just wondering whether the scheme that we're interpreting has to include the 2016 order as well, as you're not challenging the vires of that. And I'm not sure where the provision, I can't find it at the moment, the provision which points at which factors can be taken into account when setting the fee. For example, the benefit to the applicant or the costs of other applications or fees charged in other countries. But does the scheme incorporate those factors and also the maxima that are set in the order?
The scheme will encompass all the legislation, primary legislation. Let's stop there and I'll come to the order in just a moment. The scheme encompasses all the primary legislation, but the basic message that you get from Unison and JCWI and first principle statutory interpretation of the BNA is that if a statutory right is created to citizenship, then an empowering, then then delegated legislation cannot cut that right down. That's the submission. Cannot cut that right down. So, I mean, it's possible as a matter of language to say the scheme includes the primary provision that is in, I think it's the easiest place to find it, probably the statement of facts and issues.
I think the provision I was thinking of is section 68, subsection 9 of the 2014 Act, which is page 1349.
Yes, it is. It's also in the SFI, Statement of Facts and Issues, at EF 48, which is where I naturally think of it, at 68.9 towards the foot of page EF 48. Now, I mean, my submission would be that despite the statutory injunction in 68.9 to look only at the matters listed there, it's trite law that if you've got a right created elsewhere in the statute, you can't avoid the fact that that right exists and take it into account.
So this is something which is not conventional statutory interpretation. What you're saying is that however clear section 68 is, and it forms, and however it is that it forms part of the statutory scheme for examination, still there is an overriding rule. I mean, you may be right, I'm just trying to test it. There's an overriding rule that you cannot take away the right that Parliament has conferred by exercise of what I think you earlier called ancillary powers.
Yeah.
Even though looking at the section on its face, there's nothing there which expressly tells you that. So this is a new, as it were, override put into legislation, which is not covered, I think, by conventional statutory interpretation.
Well, I would say that it is. It's not a new override, it's a prior override. The PLNA 1981 was created a readily recognisable scheme. And you won't find any mention anywhere in any of the material relating to the enactment of 68.9 reflecting a desire to alter the bite of section 1.4 or any of the other provisions. It's quite easy to see how 68.9 in this paradigm case of say leave to remain or naturalisation or whatever operates. But it's not exactly a difficult point of statutory construction, my respectful submission, to say that you can't use a subordinate regulation power to cut down, to defeat the right deliberately conferred by Parliament as part of the scheme.
Well, you can't take that all the way, because suppose the fee was £1. You wouldn't, I think, accept that somebody could come along and say, I don't want to pay £1, I just want to make my application.
Yeah.
There must be a point at which
Yes.
a fee can be properly laid down.
Yes.
So your test is not the same as saying the right has become ineffective, because we're talking about affordability for a particular stratum of society. An important point, don't get me wrong, but it's not like the Strasbourg jurisprudence of saying, has this right become virtually ineffective? Has the very essence of the right gone? We're not in that territory.
Well, I mean, let me answer that by saying I completely accept the question of fact and degree involved in the level of the fee that will engage the line of thought of paragraphs 103 and 104 of Unison and JCWI, and mean that the right conferred by the BNA is being rendered nugatory. But there plainly is a point on the basis of both JCWI and Unison where it is right to describe the right as being rendered nugatory for the clerk, for a large group of people who are the intended beneficiaries of the right. I mean, that's one way of putting my case. So we all know that the children in the position of O are precisely the intended beneficiaries of the right. The parliamentary material all shows that. They can't exercise it. And that's enough, which is effectively what Mr. Justice Jay is saying. Lord Hodge had a question.
Yes, when you speak of the statutory scheme, clearly you're not talking only about the BNA itself. You have to look at subsequent legislation that impinges upon it. And we've seen from the Statement of Facts and Issues that Parliament in primary legislation in 2004 empowered the executive to prescribe fees that exceeded the administrative costs and took account of the benefits that the department believed would accrue to the person to whom the application related. And then we got the 2006 Act. Now, it's a fundamental principle that that subsequent legislation can qualify prior legislation. And would that not be a distinguishing factor from the circumstances in JCWI, that there is express legislation which has allowed the executive to ramp up the fees to include the benefits that are likely to accrue to the particular applicant from the particular permission or particular right that is conferred?
Yes, but I mean, with respect, that's question making, because for the group of people who are the intended beneficiaries of, say, Section 1.4, there is no benefit that they can gain from the exercise of the right because they can't make the application. And I think I've already submitted that the line of thought that says it's enshrined in primary legislation, so I don't mean to dismiss it by calling it as a line of thought, but the thinking behind the primary legislation enabling the Secretary of State to charge more than the administrative cost has an obvious significance for cases like indefinite leave to remain or sponsorship fees or premium services, all the various sorts of things that are set out in the order. But it has very little relevance to a statutory right created for the very class of people who are being rendered incapable of exercising it. Now, that doesn't mean that the power to charge and enhance fees is not part of the statutory scheme. It's simply a question of thinking through what the significance of the existence of that power is for a case in which someone wants to claim the entitlement under 1.4.
My difficulty here is that Parliament has conferred without restriction. For example, earlier on in the 2004 Act, the power on the executive to charge enhanced fees and hasn't restricted it to exclude, for example, Section 1.4, Section 1 subsection 4. And on what basis, where there is primary legislation giving this general power, are we to read down the subordinate legislation made under a successor provision to those to which I've just referred?
Because there's an inherent conflict between the power to charge more, more than the administrative cost of the fee, and the rights created by 1.4 if the resulting fee is set at a level which defeats the right. I mean, it's not saying that there isn't a power to charge more. It's saying that the power is limited by the subject matter of the fee, namely the ability to obtain citizenship. It will bite differently in a case of indefinite leave to remain or sponsorship, where there is an obvious benefit to the applicant. They gain their indefinite leave to remain, or they gain sponsorship or sponsor's license. There's an obvious relationship there, and the subject matter on which the power can be exercised. But if you come back into 1.4, the context is just different. It's not that the power doesn't exist. is that the context in which you exercise it, you, Secretary of State, exercise it, is different. Of course, you have to respect the subject matter of the right in question. Now, in my submission, that's not difficult. It's not asking the court to say the later provisions don't exist. It's just recognising the context in which they have to operate.
Yes, but we also have to recognise that that Parliament has chosen to confer this power without confining it to particular contexts.
Because it doesn't need to. It doesn't need to, because you go back to the language of 1.4. It doesn't need to say, oh, by the way, you can't defeat the right in 1.4. It doesn't need to do that at all. It's a power. The power, not a duty. It doesn't say you must charge X. I'm specifying in this primary legislation that you must charge £1,000. It's not doing that at all. It's creating a statutory scheme, I completely agree, which includes a whole series of powers, all of which must be, in my relatively simple submission, exercised on the basis of a recognition of the underlying right that the particular fee relates to. And unsurprisingly, the different powers will bite differently depending on the subject matter of the right that they're dealing with. You don't need to say that on the face of the legislation. It's just inherent in the situation.
Thank you.
Well, those are, I think, my submissions, unless I can help in any other way at this stage.
I think, Lady Rose, did you want some reference to be made to the order, or no, you're content with what you've heard? That's fine. Well, Mr. Drabble, thank you very much. Sir James.
My lords, my ladies, I'm going to divide my submissions into two parts. The first part is going to deal with basic submissions on the statutory scheme and its natural meaning and effect. The second part is then going to see whether there is, in the case law, applicable to our context, a principle or set of principles that should lead you to adopt something other than that approach. In other words, looking at it to determine its natural meaning and effect. And in that context, I'm going to consider Whittam, I'm going to consider JCWI, and I'm in particular going to consider Eunice. And then finally, but very briefly, for reasons I will come to, I want to deal with the Schedule 3 of Para 2, or Para 2 of Schedule 3, or the other way around, the 1961 Convention on Statelessness. So on the basic submissions on the statutory scheme and its meaning and effect, I make three submissions. The first is that the right in section 1.4 of the BNA, page 1311, is, as it always was, expressly subject to an application being made and to the fees regime that Parliament sets out. And that means, when looking at the composite statutory scheme, an application made in accordance with the system of legislative regulation of applications that Parliament has seen fit to set up and approve. The right in 1.4 is not being cut down on that basis. It's just one aspect of a series of rights and conditions that Parliament has set up in this statutory scheme. And the constitutional premise, therefore, is that Parliament in section 1.4 was subjecting the right to whatever rules and conditions Parliament saw fit to create governing that mode of application. And Parliament would have expected that any rules or conditions arrived at by Parliament and attached to the application as conditional, and bear in mind that section 1.4 itself refers to the need for an application, and 1.3 does so in with even greater clarity, making it clear that it's conditional. Parliament would expect that whatever rules and conditions it arrives at attached to that application would be adhered to. So both that right in 1.4 and the conditionings governing applications, and indeed the conditions for the right itself arising, are parts of the same scheme, applications and their conditions are integral to the scheme. And that has always been so. The historic position, as you know, is complicated because the relevant legislative scheme has gone through any number of different iterations. The historic position is, as noted at the very outset of the Williams decision, don't need to turn it up now, but see Williams paragraph 1, page 1768, and we've set out that position history up to the present day in little detail, both in the SFI and in our case, where the strands are drawn together at paragraph 25 on page 94 of the bundle. So all of my learned friends' submissions, based on the contemporaneous material and the white paper and everything else, went simply to establish that entitlement and the bases for it to nationality in certain circumstances. And that Parliament drew the lines that it did in relation to that set of issues is entirely uncontroversial. But it does not answer or advance the fundamental point here, which is what was Parliament's intention in setting up the fees regime. Its focus is entirely on the setup of everything else apart from the fees regime, which isn't controversial because of the conditions you have to satisfy apart from the application being made and the fees and all the rest of it is clear on the face of the legislation. There are various different other conditions that have to be satisfied. They aren't controversial, but he's focusing on the wrong target. The question here is, what was Parliament's intention in setting up the fees regime? And it's perfectly clear what Parliament intended so far as that is concerned, because the application is made a condition, in effect, of the right arising. And by references to application, it meant an application which conformed to the powers that Parliament conferred in relation to that application, which included, as you will recall, the power to charge fees in section 41 sub 2 in its original form at 1327. And it also included a very specific provision in original section 42. Can I just invite you to find again, if you would, our supplemental bundle, which is mercifully extremely short and just gives you some of the conditions in some of their original forms, some of the sections in some of their original forms, I think in particular from the British Nationality Act. So you'll see in relation to our supplemental bundle in the index the various dates which applied. But I want you to go, if you would, to page AA page number 3, it says on the bottom of my little physical clip, as it were. And I'm after the British Nationality Act, section 42, and I want the version, it says version 1 of 4, date not available, so that's from the beginning, as it were, to 20th of July 1993. And you will see that what Parliament did when it passed the British Nationality Act, therefore, in 1981, this being the original version, section 42, not being behind the relevant physical tab, at least in the bundles, it specified that a person positively was not to be registered as a citizen of any description or as a British subject, and a certificate of naturalisation shall not be granted to a person under any provision of this Act unless a fee has been paid in accordance with the Act. And you'll see also in that section at sub 3, any provision of this Act which provides for a person to be entitled to registration as a citizen of any description or British subject shall have effect subject to the preceding provisions of this section. So what Parliament is doing is making absolutely double clear that it is treating an application and the payment of the requisite fee, therefore, as being a condition to the right arising. And that, we respectfully submit, is a complete answer to my learned friend's principal submission, which appeared to be that there was some basis under the legislative scheme for concluding that the application process, including in particular the payment of fees, was in some way, shape or form to be regarded under this legislative scheme as being simply ancillary. That's impossible as a submission in the light of section 42.1 and 42.3, quite apart from the fact that even if those sections didn't exist, it's entirely clear from the face of the legislation creating the right that an application is an essential condition to its arising. And that's simply put beyond doubt by 42 sub 3. I should add, for the sake of completeness, that as the various courts that have considered this issue have noted, section 42 has subsequently been repealed and has been replaced in its substantive form by various provisions in various other orders and regulations. But as the Court of Appeal held in Williams, at paragraphs 40 and 46, nothing essentially has changed in terms of the basic nature and setup of the regime. My lady, yes.
Where was the regulation making power in respect of fees in section 42? Because I take your point, but then as Mr. Drabble showed us, I think originally the fee was £35, which I gather equates to about £120 in today's money. So was there anything in the power conferred to make fee, or what was it made by regulation under the 1981 Act, and where was the power to do that?
I think, my lady, the answer to the question of where was the enabling power is section 41.2 as originally enacted, see page 1327. I don't know if I'll be able to find the original regulations as made, but you'll see that regulations made under that section. So 41 sub 2 as originally enacted at the bottom of page 1327. You see that? And then the form in which they were to be done, they were to be made, was negative resolution. See section 41 sub 7 on 1328. And I don't think otherwise there was much that was said about the nature or form of them or anything else. And so what then happened, as you know, in terms of the legislative history, is that there was increasing control. The regime became increasingly prescriptive, culminating in the powers that you've been discussing with my learned friend in 2004 to say you can put it up beyond the level of administrative costs. And we know there's lots of case law that would otherwise potentially prevent you from doing that. That's why you need the primary legislative provision of the kind you see in the 2004 Act. And it then led to a greater degree of prescription, and this time covering the whole sphere of nationality and immigration effectively in one place, in the 2014 Act, which you have behind tab 3, page 1348 and following, again, which you've looked at. And the differences that featured in that regime were not merely, just to summarize, a greater degree of primary legislative prescription and control, but also a greater degree of callback, a greater degree of oversight for Parliament, because what the 2014 Act then did, just in terms of its basic structure, was to say you've got to make a fees order, and the fees order has got to do these various things, including setting out maxima. And then once we've given you permission to do that under the affirmative resolution procedure, you can buzz off, but you better come back when you've done it pursuant to the negative resolution procedure and tell us where below that maximum you've actually set the thing. So that's the basic structure of what happened, but I hope that answers my lady's question, at least about the 1981, and gives you that. Anyway, that we say Mr. Drabble is keen, if humanly possible, I think in his submissions, to keep this focused on the 1981 Act. As far as we're concerned, that's absolutely fine. But what you've got to do when doing that is look at section 42. I say fine as a starting point, but if you're going to do that, you look at section 42, and that tells you that under no circumstances and in no way could this possibly be described as an ancillary provision or as something which is other than what appeared on the face of 1.4 to be a condition. So that's the first point, but the right itself in 1.4 that he relies on has always been subject under the same scheme to an application and all the various provisions that Parliament has seen fit to enact governing applications and fees. The second submission we make about the statutory scheme is that the legislative scheme involves, and I've to some extent put this point out there already, but it involves a careful scheme of control bringing back to Parliament the making of the orders and regulations, and indeed the specification in the primary legislation of the limited, and we note rather unusually exclusive, factors that can be taken into account. I think it was section 68 sub 9, and that scheme is precisely contemplated in the detailed enabling provisions in the primary. And after all, this is about the enabling provisions. What are the controls? What's the correct interpretation of what Parliament in the primary legislation was doing? The first point I make about the scheme and the approach and all of that, I think to some extent echoes a point that my Lord Hodge was putting to my learned friend, which is that the true focus of the question of interpretation that confronts this court is sections 68 to 74 of the 2014 Act, which, as I say, starts in the bundle at 1348. It is that scheme that is to be interpreted as a whole. It is that scheme that is to be interpreted as it now exists. This is not one of those cases where you can go back to the original legislation on a point of difficult interpretation and say, well, it must have meant that in 1981, and now it must mean the same thing, subject no doubt to always speaking legislation and that principle. But it isn't one of those cases. What you actually got here is a current legislative scheme which pulled together bits from lots of different schemes and arrived at the scheme that you see set out in section 68 to 74. So if there was an implicit submission of principle made by my learned friend that really your focus needs to be on the 1981 Act almost exclusively, we would disagree with that. I'm not sure he did make that submission or could do, but we say that the focus of this is on 68 to 74 of the 2014 Act. And as you know from our case, I don't go through all the provisions and the structure again in detail, but there is power in the Secretary of State conferred by the primary legislation by order to require an application in connection with nationality to be accompanied by a specified fee. If you just go for this purpose to the 1348, so we can trace the provisions through, you will see that's the purpose of 68 1 and 2 on 1348. In making that sort of order, the sort of order, the fees order referred to at 68 sub 2, there is a specific form of legislative control that is required. It's got to be with the consent of the Treasury, no doubt on the basis that they keep their hands on the purse strings, and by affirmative resolution. And those two features are evident from sections 69 sub 1 at 1351 and 72 sub 2 sub J at 1357. So it's got to be with the consent of the Treasury and by affirmative resolution if it's the order that is being done. The order itself, per the primary, has got to set out the maximum if it's a fixed amount. See for that purpose section 68.5 and 68.8. The amounts can be set at a level which exceed administrative costs and reflect the benefits to the individual. See 68.8b and 68.9. So that's the replication of the 2004 Act in the substance of the 2014 composite legislative scheme. And you already have the point, but just to double note it, 68.9 makes very specific provision for the range of matters, and they are exclusive matters. They're not just including the following, they may have regard only to, and then there are the set of factors that sit in section 68 sub 9. And finally, to note in relation to the primary, that there is, as it were, permission granted for that secondary legislative scheme to provide for reductions, waiver or refunds. See section 68 sub 10 sub B. So under that scheme, with that level of prescription by way of enabling power and legislative and parliamentary control, you can already see the shape of what is happening. Much more intense levels of control by Parliament, much more direct, clear and pressing parliamentary control in the various forms that they thought appropriate, with the distinctions which you're very familiar with between affirmative and negative resolution procedures. And under that regime, the fees order is made by affirmative and the regs are then made by negative, but they've got to conform to the maxima and the other bits and pieces that are in the fees order. So the fees order starts at 1366. And you'll note from Article 3 on page 1371 that the Secretary of State is under a duty my Lord Hodge said there isn't any order saying specify the minimum, and you're right, my Lord, but there is a duty to charge a fee. See Reg 3 at the bottom of page 1371. And then Article 10 for relevant purposes, 1384, my learned friend took you to it. It sets various maximum fees that can be charged and puts a lid on the level of fee, including a particular 7.1 within Table 7, 1,500 for registration as a British citizen. So they've set the point. Parliament, pursuant to this mechanism, has, as it were, exercised detailed control and has set that required the maxima to be set. They've called it back for a specific type of parliamentary oversight in affirmative resolution, and they've approved effectively being set at maximum levels in this way. So they've set that point, and it's perfectly plain, we respectfully submit, that they must have contemplated, if only at this stage, they must have contemplated that the possibility of unaffordability. My lady, I'm sorry.
No, that's okay. So is it your submission that even if there was in the initial regulation making power in the 1981 Act, some constraint based on affordability of the fee charging power then because of the nature of the right, that must have been swept away by the new primary legislation setting out the fee charging regime, which clearly does not envisage any constraint other than the constraints expressly provided for in that new fee making regime. Is that
my lady? Yes, I think I'd put that thought in a slightly different way, which is that I can see that my learned friend's argument might be a bit stronger if the 1981 Act had stayed unaltered. But this degree of prescription and the level of detail that you see in the 2014 Act is highly relevant to the question: what did Parliament intend when setting up the application process and the fee system? Given that, you have to construe and interpret the legislation as it currently stands. But essentially, I agree with my lady. It's just a slightly gentler way of putting the same point. So that's the fee order. And then you have the 2018 regulations themselves, starting at page 1392. They are made under the negative resolution procedure. I perhaps should have given you that reference earlier. The negative resolution requirement for these regs is in section 74(4) of the 2014 Act at page 1358. And you'll see under Regulation 10, leading to Schedule 8, Table 19, Para 19.3.1, the detail doesn't matter much, but it's at page 1476, that the fee is 1,012. And where the application is made to register by an adult, the fee is 1,126, that's 19.2.1. And there's then also in those regulations a system of exceptions and waivers in Table 9 of Schedule 2, 1434, none being applicable or made for applications for registration. And although I'm sure there are fiddly bits around the edges, the basic scheme of the system of exceptions and waivers are in particular directed at ensuring that there is the ability to deal with the most pressing sorts of cases where someone is to be removed from the country or whatever it may be, making an application for leave to remain and so on, rather than this right. But there is no exemption or waiver made for our situation. So the position is that the scheme in question was in fact considered by Parliament, both as to the extent and limit on the fees regime, circumscribing and describing in considerable detail in the 2014 Act the Secretary of State's powers, and as to the detail contemplated and specifically set up by the primary legislation when it came back through the affirmative resolution procedure. And there's an obvious logic to that. Come back and tell us, and we'll subject it to great scrutiny when you tell us what the maxima are going to be. Within that system, we give you more leeway, more discretion. We're going to have a less dramatic form of oversight and intervention, or way of negative resolution procedure in setting the actual amount, because we have the comfort of knowing that we've had a proper affirmative resolution procedure go at where the ceiling should be. But it's also clear from the primary legislation that Parliament itself has answered the question of controls and tests, which I know the court was interested in this morning. That there is no affordability criterion built in. Let's be very clear about that basic point first. There would then be, and some of this you were exploring with my learned friend this morning, very difficult questions as to how you would set up a scheme which imposed affordability as a condition or a criterion. And all of those difficult questions, we respectfully submit, are effectively dealt with by the detailed nature of the composite legislative scheme that I've just described, with the intricate levels of control, with the setting of maxima followed by a Secretary of State and negative resolution setting the actual amount. And that scheme under the 2014 Act also provides the answer to the £1 million fee question that my Lord Stevens raised, that you will have seen the Court of Appeal in Williams was interested in to some degree under the regime that it was considering then. But that's provided, the answer to that question is now provided by Parliament, because it's set maximum. So you can't set £1 million under this legislative scheme. They control the ceiling. And indeed, they also control where the Secretary of State places the fee below that ceiling. But to some extent, what that does is to illustrate the constitutional difficulties of the my learned friend's argument, and the constitutional difficulties which I suspect that the court's questions to him on this subject this morning were directed at, which is how are we meant to do all of that? I mean, you could set up affordability in a whole variety of different ways, but how are we meant to do that? And more particularly, how are we meant to do that in a way which respects the absence of any affordability criteria, despite the level of prescriptive detail in the legislative scheme that Parliament has chosen to set up? And how do we do that if we're going to do it as courts? How do we do that in a way that could possibly be said to be consistent with the detail of that scheme? In the end, you can put the same point in a slightly different way. In the end, my learned friend has to argue for, and does argue for, a scheme which is radically different to the scheme on the face of the legislation book. On his case, and I'll come back to this point, all entitlements at least must have a mandatory exemption or waiver. Presumably all discretions that might be accessed by the right to make an application likewise. And everything is subject to an unspoken affordability criteria which would cut directly across the parliamentary expression of will that it wants fees to be charged, that it is going to exercise controls in all of these various ways, including setting maximum levels of fee and then controlling where the Secretary of State ultimately places it under the negative resolution procedure. So we say that is absolutely critical to the proper analysis of this legislative scheme, and that's the second submission of 3. The third submission is that it is, we submit, plain that Parliament appreciated, and appreciated clearly, that the fees set under this legislative scheme would be, overwhelmingly likely, but would be unaffordable for some. And there's a structural and a factual aspect to that submission. Structurally, as I think my Lord Stevens pointed out, unless you set the fee at £1, almost any system of fees where the fees are significant carries with it the potential for some applicants not to be able to afford the fees. That is very clear in the context of this scheme and the nature and structure of these provisions, both in the primary and then in the parliamentarily approved fees order, against which it appears no challenge is made. It specifically made provision in the primary legislation for confronting the maxima in relation to each area, including this one, and for itself to have affirmative resolution scrutiny over that. And those maxima plainly carried with them the potential for unaffordability. I think we may have lost Lord Briggs, my lord. I'm sorry, he's got I was about to say a health warning above his box, but it's the little sign saying.
Yes, Sir James, thank you for bringing that to my attention. If we could pause to see if he will return to join us, and we'll find out where he lost out. Lord Briggs, can you hear us?
I just can now. I've lost you for about 2 minutes.
Yes, well, Sir James was saying that it was plain that Parliament appreciated clearly that the fees arrangement would be unaffordable for some, and he was making 2 points. Firstly, that structurally, any system of significant fees carried with it the potential for applicants to be unable to afford the fees, and he referred in that regard to Parliament's approval by the affirmative resolution procedure of maxima in the order. So, James, if you wish to expand on my summary of your submission.
No, that's a perfect summary, if I may respectfully say so.
Thank you.
The next point, if that brings Lord Briggs up to date, which I think it does, the next
Thank you.
theme is that, as you're aware, the primary legislation also specifically empowered, but did not require, the making of exemptions or the giving of waivers for fees. And that is, we respectfully submit, flatly inconsistent with any suggestion that the legislative scheme has affordability, as it were, a requirement of affordability built into it. That's the very purpose of granting exemptions and waivers from the fees. But it left and specifically permitted those judgments to be made, and they were then made, as we've seen, chased through in the various pieces of subordinate legislation that were then made. Now, of course, the position is, as I entirely acknowledge, that secondary legislation is made by the executive, whatever the degree of scrutiny by Parliament. But these courts, in a whole variety of contexts, not least the ECHR, have drawn a series of real and important distinctions. One has in mind the famous paragraphs from Lord Ree's judgment, and I think it was JS, the bedroom tax case, about the significance of affirmative resolution procedure for the margin and for the respect that the courts afford. We're not in that context here, but we do submit that setting up the scheme in this way is highly relevant to the varies question, because the varies question is ultimately about Parliament's intention in the relevant part of the legislative scheme. And the relevant part of the legislative scheme are the provisions that enable fees to be charged and place constraints upon that fee charging power. And the fact, therefore, that Parliament has gone to the trouble that it has to set out the degree of control that it sees fit, and in detail and prescriptively in the primary, but has then called back different and distinct types of decision for greater or lesser parliamentary oversight, is, we respectfully submit, highly significant to varies. And they evidently did so, and they permitted and indeed required this fee structure to be put into place in plain recognition of the fact that, or perhaps two basic things. I know we're not justifying this on the merits as a scheme, but they plainly set up that form of control, those species of control, on the basis that the fee scheme was important in the public interest to defray at least some of the cost. We saw from the explanatory memo it's about half, I think, which would otherwise fall on the taxpayer. And it did so essentially on the principal basis that many of these applications, including specifically this one, conferred serious benefits on individuals. It also did so in terms of the various decisions and distinctions that were then made, exemption or no exemption, waiver or no waiver, what level, what maximum. All of those decisions were based on the clear understanding that this legislation, the 2014 Act, was covering a broad canvas. My Lord Stephens.
I understand you to be accepting that the question of varies doesn't depend really upon what is said in Parliament. It depends upon the enabling legislation, whether the enabling legislation permits the subsidiary legislation to be passed. And just taking that theme on, it really matters not, therefore, what the policy behind the subordinate legislation is either. So whether it is to recover costs from and to be self-supporting, which is all in the public interest, yes, obviously, but it makes not a pick of difference to the various.
I entirely agree. I entirely agree, which is why this was going to be a 30-second footnote and not a submission.
Right, I'm sorry for making it longer.
Don't worry. The final 10 seconds of the 30 seconds was going to simply be to say that they must have understood and did understand that if you rob Peter, you have to pay Paul. And part of the reason for keeping fees at a certain level is no doubt that you do or don't exempt them in other areas. So, but my lord is entirely right.
Maybe a jury point, Mr.
It may be a jury point. I'll try to keep them to a minimum. That was it. That was the only one. If my lord will forgive me. My lord, I said there was a structural point. I said there was a structural point in relation to this claim that Parliament would have appreciated it. And again, I don't want to make more of this than it deserves, but the main submission I make is the structural one. That's the most important. But the fact of the matter is, as you've seen from our case, that there was and has been over the years repeated attempts made to cast the legislative scheme so far as these applications for these children, to cast the legislative scheme in a different form. There were repeated attempts made to amend various bits of legislation, including the fees order and various other bits and pieces when primary legislation was under consideration. And the cry was, this is all terribly unjust. There are going to be lots of people who can't afford this. And Parliament repeatedly stuck to its guns and repeatedly decided that this scheme should exist in this way without, to put it back into structural language, a mandatory requirement for there to be a waiver or an exemption for this category of person. But these very people, indeed peers and peeresses who were advancing the case, were doing so, I think, on clear briefing from the claimants in this case. But the point was repeatedly raised and Parliament decided to stick to its guns. So
James,
well, I'm sorry.
So James, given Lord Stephen's strictures about the boundary of a virus challenge, would that not also apply to these parliamentary debates?
My lord, I think not with quite the same force. I think you are entitled, as part of your interpretive exercise, to examine whether or not particular proposed legislative provisions were or were not taken up by Parliament. And so it's, at the very least, slightly less of a jury point. Lord Stephen is going to tell me it's a pure jury point.
You're interpreting primary legislation passed in 1981 and the 2014 Act by something that was said in Parliament in relation to the regulations. And I have great difficulty with it. You have to look at what the power is, and that power is in the 1981 and the 2014 Act.
My lord, I entirely agree.
Yeah.
I entirely agree. But I think I'll chase back overnight. But I think that at least one of the attempts was made in the context of a proposal about primary legislation. But I'll double check on that. In any event, it's a short point, and it rather brings to mind Lord Bingham in Countryside Alliance, saying achieving things by political means when you failed to do that in Parliament. Anyway, leave that on one side. That's the factual side of it, for good or ill. So the submission that we make under the natural meaning and understanding of this legislative regime with all its glorious detail, it is the short one, which is that the Court of Appeal in Williams, Lord Justice Davis, Lord Justice Underhill and Lady Justice McCurr were correct at paragraph 45 in the crisp analysis they gave to this scheme, page 1776. Parliament's intention, we submit, is absolutely clear in the detailed enabling provisions of 68 to 74 of the 2014 Act. The fee requirement is absolutely explicit, as is the ability to set it above cost, as is the ability to provide for waiver or not, as are the secondary legislative procedures, as is the requirement to set maxima. All of that is in the primary legislation. There is no basis whatever, we submit, for treating any of the conditions in the legislation as subordinate to the others, or as characterizing one part of the scheme as ancillary and another part as primary. And if ever there was clarity about that, or a lack of clarity about that, which there wasn't, Section 42 of the 1981 Act made it absolutely clear in its first subsection and in its third subsection. And so we do submit that there is no proper basis to, and every reason not to, infer that the parliamentary intention was, and this is what my learned friend would have to persuade you of, that the whole scheme should be subject to reasonable affordability and some form of implicit reasonable affordability condition as to lawfulness. Why, if that's so, it may be asked, make provision for secondary legislative decisions subject to parliamentary oversight to be made about waiver, about maxima, about affordability and so on? I mean, it's impossible to understand why the scheme would be set up that way if that was Parliament's understanding. Parliament would well understand, we submit, that the setup would involve decisions about where waiver should or should not be granted, where exemption should or should not be granted, and would well understand that with such a condition came not merely an inability to receive the fee, but the whole administrative process that would need to be gone through in order to determine what would no doubt be the string of contested applications saying we can't afford it. We also submit, finally, on this aspect, that Parliament can also be taken to be well aware of the practical point, or the two practical points that may be made as part of the context in which this legislative scheme sits. And the first of them is the point which is made in Williams by the Court of Appeal at paragraph 52. I'm sorry, paragraph 51 on page 1777. I just invite you to turn that up to remind yourselves of that paragraph. And to some extent, that's at least an aspect of, or a reflection of, or something like at least, the point that I think my Lord Stevens was making and other members of the court made this morning, which is the span of time over which affordability is to be considered. I don't know if friend's answer to that, which is a fair one, is to say, well, Parliament must have intended that the thing should be affordable at the moment the right first arises. One understands that, but as an intensely practical point, you don't lose the right, as it were. And so affordability is more likely to be postponed than lost. Of course, all of these things, given the complexity of the scheme, are subject to exceptions and so on, but we're dealing in generalities in terms of understanding and context here. So that's what I wanted to say about the nature of the scheme if you approach it, as it were, untrammeled by legislative presumptions. And then, as I understand it, what my learned friend really seeks to do by a variety of different routes in his written case and in his oral submissions is to introduce principles of interpretation that, on his argument, should skew that natural meaning and effect. It doesn't terribly matter which one you take. The courts have relatively frequently identified sets of principle which have the effect of requiring parliamentary intention to achieve a surprising result, to render Parliament's intention to be made more clear through the application of the principles. So you have the principle of legality, you have the JCWI principle, you have the principle in Whittam about fundamental constitutional rights. They're all essentially designed to achieve the same end, which is to require Parliament's intention to be expressed with particular clarity in circumstances when it's doing something surprising. and my learned friend says we're in that territory. I think with respect to him, at least in his written case, I'll come to the reference in a moment, but at least in his written case, places that, even if those principles or something like them are in play, places the principle far too high. Ultimately, all of those principles are simply principles of interpretation, as many courts and judges have emphasized over the years, including, I think, recently the Court of Appeal in Dolan, one of the COVID restriction cases, my Lord Sales in Privacy International. They're all ultimately, therefore, simply tools for assessing whether Parliament did or did not intend to do the thing which is said on one side it has done. But come to the specific bases on which those principles might or might not be in play. We have, first of all, the Witham case in the fees context, and that is at page 2409. And it was one of those cases, a bit like Unison, which involved the imposition of fees that needed to be paid as a precondition to getting into court, to obtaining access to justice. And it turned, like Unison, therefore, on the fundamental constitutional nature of the right in question. And we respectfully submit that on the basis of the concession that has been acknowledged repeatedly in this litigation and is made again today by my learned friend, it doesn't really help here, where we are not dealing with a species of right of that nature. And for that same reason, it doesn't actually help to emphasize what we all agree is the importance or are the tangible benefits of citizenship. And for that reason also, we respectfully submit that the Court of Appeal in Williams, at 1775 paragraphs 44 and 45, were right to reject a submission that sought to engage that principle. Parliament needs to make it super clear that this is what it's intending, on the basis of reliance on the Witham case, 1775, para 44 and para 45, which you're very well aware of. And we would respectfully add, by way of footnote to that, that one needs to be very cautious about restricting that sort of, or the engagement of that sort of principle of interpretation for principled and constitutional reasons of the kind explained by Lord Justice Laws in Lightfoot, which we've quoted in our case at paragraph 41, electronic page 100. And if you want the passage in the raw, it is on page 1583 between the letters B and D, essentially saying you need to be very cautious about applying that principle too broadly, because these are important rights and they justify a departure from the normal rules, the normal canons, by reference to which the courts seek to ascertain Parliament's intention. Parliament, of course, ultimately being constitutionally sovereign. And a similar set of points were made by Lord Justice Simon Brown on appeal. So it must have been, I think, Mr. Justice Laws, he then was in Lightfoot, I've given you. But Lord Justice Simon Brown made a similar set of points in his additional ground for affirming Mr. Justice Laws' decision in Lightfoot at page 1602 between letters A and C. The true position we submit, therefore, in terms of the nature of the right that you're considering here, the 1-4 right, is and was considered by and set out by Mr. Justice Ouseley in the AHK case at paragraph 45. Don't need you to go there, I'm not sure it's even in the bundles, but it was cited and relied upon in the context of the Article 8 analysis by the Court of Appeal in Williams at page 1779, paragraph 60, where they noted that there was an entitlement in a state to set the terms for and apply its tests to any application for naturalization, and that at least Article 8 directly was unlikely to be engaged. See Genovese and Malta, which was set out in paragraph 6. But it was accepted, and has always been accepted by my learned friend, was accepted by the Court of Appeal in our case, that there isn't therefore a fundamental constitutional right in play. And once that is accepted, introducing, and I'll come back to this in when I'm dealing with the principles and the submissions, but adding whatever adjective you choose, such as important before the right, doesn't actually advance the analysis. This principle is triggered only by those sorts of rights. Within principle. Note finally on that respect, recording that acceptance below, Lord Justice David Richards, paragraph 57, page 132. So then the JCWI principle, and again, I'll come back to make the submissions in due course, draw the submissions together, but just to note, the JCWI case starts at 1551.
So James,
Yes.
am I audible?
Yes, you are entirely. I'm sorry if you had your hand up for a while.
Just before we leave the previous point,
Mm.
is it right that the conferring or not conferring of British citizenship on a 10-year resident child affects whether that child can vote at general elections at 18 and onwards? It was suggested that that was so this morning. I think you're saying politely pass.
I am saying politely pass, but I would also say rather more positively that I will check.
Yes, well, assume purely for the purpose of discussion that it does. Would that effect of the availability or non-availability of that right have any consequence for the Witham analysis of whether it's in any way constitutional?
My lord, not so far in terms of the case law's suggestion. I mean, you've seen from paragraph 60, we're not going to get sucked into whether Article 8 is engaged, but you've seen that the convention jurisprudence at least appears to suggest that Article 8 is not engaged.
No.
But by this, and I suspect that they would.
I wasn't really thinking of the right to vote as being an Article 8
No.
point, rather basic constitutional point.
Yes, but I think you were saying, well, if you can't do that, it may not engage Article 8, but because it might have indirect effect on other rights, it might do. Was that the thinking?
No, I was just thinking more directly that if the effect of an unaffordable fee is to prevent poor children who otherwise qualify for citizenship from voting, but better off children not to adversely affect them from voting, whether that has any consequences in terms of engaging the Witham type of analysis.
My submission would be that is too indirect an effect, and there isn't a suggestion in the case law that you analyse it in that way.
Okay.
My lord, sorry, Lord Hodge.
Yes, I mean, it may be the answer to Lord Briggs is the passage you were looking at earlier from Lord Mance and Lord Hoffman in Banco, which distinguished between the right of abode once conferred and the process of it being conferred.
Yes.
One could think of an analogy in the context of a right to vote in an election.
Yeah.
Yes. Yes, thank you.
Some more, but I'll check the factual position, my lord.
I would be grateful. Thank you.
Got that. In any event, I mean, it sounds like a trite answer, an answer to a serious question, but the point is not being run against me massively. Many points are, but that one isn't. Either at the specific level or at the fundamental. No one is suggesting this is or engages those fundamental or constitutional rights, whether directly or indirectly. So JCWI The first point perhaps to note in relation to JCWI is that a very, very similar point that was run and considered by the Court of Appeal in Williams, because as you see from page 1775, at paragraph 43, specific reliance was placed on fewings. But we respectfully submit, so that's a pretty similar looking principle, but we respectfully submit that the correct approach in principle was the approach of the Court of Appeal in Williams, paragraph 45, and of the Court of Appeal in our case. In other words, to ask the question, ultimately, whichever route you come at this from, the ultimate question, whether under JCWI or anything else, is what did Parliament intend? What's the correct interpretation of the enabling powers that you're considering if the challenge is a valid one? Can I just go back to the Court of Appeal's judgment in our case? Page 133 of the electronic bundle is perhaps the clearest. And I want paragraphs 59 to 63, which are in part addressing the point on which my Lord Justice Singh, as you see from paragraphs 121 and 122 a bit further on. This is partly about the point on which he was strongly agreeing with his own judgment in Al-Anin, but it's also more fundamentally about the correct approach under JCWI, which is ultimately that it all collapses into the same question, which is what did Parliament intend by creating the legislative regime and the enabling powers that it did. That's the conclusion of paragraph 61 in particular of Lord Justice David Richards. And that was the conclusion of Lord Justice Singh at paragraph 122 on page 147. And we respectfully submit that that's right. The one thing that can be said with absolute confidence about JCWI is that it is not authority for the proposition asserted at paragraph 49 of my learned friend's written case. It does not establish, in his words, quoting directly, an interpretive presumption that a law passed by Parliament is not intended to undermine or defeat rights unless that consequence is expressly provided for in primary legislation. And the fundamental problems with that are that you've got to focus on the right, which here is, or the right obligation or the right set of provisions, which here is all about the enabling provision to do with fees, for reasons I explained at the very beginning. But secondly, even if you had the various principles that we're dealing with, JCWI, principle of legality, constitutional right in issue, whichever one you choose, it's absolutely clear from repeated decisions of this court over the years that you don't require express words. It can be express words or necessary implication. Necessary implication being as explained by, in particular, Lady Hale in the smoking in public places case, the Black case. I think we cited in one of our footnotes. So you go express words or necessary implication, but ultimately it is a principle of interpretation. These are principles of interpretation. So the question does indeed collapse into the question posed by Lord Justice David Richards at paragraph 61 and Lord Justice Singh at paragraph 122. Then we have unison. Again, you'll all be very, very familiar with unison. And we respectfully submit that unison was decided essentially on the basis that the nature of the right involved was fundamental / constitutional, essentially on precisely the same basis that Mr. Justice Laws decided that issue in Whittam. Same thing, fees stopping access to court. And we know again from lots of other legislation to do with regards to the topic of legal aid, that you might get a very different answer if the question is, do you have to provide legal aid to everyone? But fees operating as a barrier on access to justice. That's why Lord Reid spent so long exploding the various misunderstandings of what was meant by the concept of the rule of law, and that it wasn't actually something which the government in any sense was right to treat as involving customers and chips on the table. It was something more fundamental. So our submission on that line of case law, we make 4 submissions on that line of case law with that brief introduction to them. And the overarching submission is that great care must be taken not to extend either unison or the other cases beyond their proper boundaries, or to divorce them from their context and facts. First of all, we submit, and this is the first of the 4, unison does not purport to lay down any general principle that all rights, including all statutory rights, must be reasonably affordable if they have a fee scheme attached or an application scheme attached to them. Unison at its core is about, and the reasoning and conclusion of the court was driven by, the special fundamental constitutional right of access to justice. And there is a real concern that underpins that first provision, that first submission, for reasons you will, I'm sure, well understand. The real concern here is with the breadth of the principle that my learned friend's logic contends for. In effect, an extension of the unison approach to all entitlements, so long only as you can, as it were, split them off from and ignore an application condition and say, well, there's a right. That isn't the principle expressed in unison. And it would be a principle of extraordinarily wide and damaging application were it to be accepted by this court. No doubt recognizing the thoroughgoing unattractiveness of that as a position or species of logic to which his submission tends, my learned friend in the course of this litigation has sought to confine the principle. Prior to his oral submissions, he tried 2 attempts at doing that to make the position which he contended for about reasonable affordability acceptable. The first was the introduction of the adjective being important rights. But the short answer to that is that as a controlling principle is simply made up. There is no support for it in the case law, and it is impossible and incoherent as a species of control, we submit, because it provides no principled limit. All parliamentary rights are important in their own way and to someone. Secondly, and this still, I think, is in play, my learned friend has accepted, I think, at various points in this litigation, see by way of example, I'd invite you to turn it up, the original JR grounds at paragraph 5.2 Roman 3 on page 497 of the bundle. The claimants have accepted that charging fees at cost, in inverted commas, would be lawful. The difficulty, of course, with that is that charging even at cost would be unaffordable to some. But a more fundamental constitutional problem is that in repeated primary legislation, Parliament has specifically and expressly permitted, see the 2014 Act and see the relevant reflecting provisions in the 2004 Act as dragged forward into the 2014 scheme. Parliament has specifically permitted fees in this very area to be set at a level which is in excess of costs. And the difficulty is that if you take away that concession, if there's some attempt to depart back from it now, you end up struggling with any form of control over the principled approach and the principle for which my learned friend contends. And so his case starts to prove far too much, because it would have to apply to every statutory right, as long as you view the right as being divorced from the application and fee process, that is set up anywhere within Parliament. It applies, therefore, to all fee charging. Every statutory entitlement must be reasonably affordable for someone, is the logic, or to all people. And that would mean, of course, that all statutory fees had to be either extraordinarily low or subject to highly administratively burdensome and costly systems of remission, waiver, challenging on affordability grounds, and so on. But the fundamental problem we submit is that attempt to say, no, I can control the principle, you can charge at cost, just simply doesn't work. I reference to the express provision that allows you to charge in excess of cost. So now the attempt appears to be made that there is a key distinction to be drawn, he said already this morning, in relation to affordability, which is based on the precise formulation of section 1.4 and the fact that it is cast, leaving fees aside, as an entitlement. But that is extraordinarily difficult, we submit, as any form of coherent species of control over the overbreadth of the principle. There is a right to apply for the benefit that other statuses might confer, which it would no doubt be said in the next case that would come before you is being defeated, and to which the logic of your judgment should apply. The gateway will be shut to the exercise of that discretion in my favour on unaffordability grounds. Hard to see in practical terms how you could contain it in that way. Equally hard to see why in principle it should be a coherent answer. The basis appears to be that Parliament has set this as a right, but that equally applies to the right to apply. It can't turn on the precise nature of the right that is created. My Lord Stevens, I'm sorry.
Sorry, what's you just drawing a distinction between a right to apply, meaning for the exercise of discretion to grant you a right? Because this is a right. I thought you were saying that section 1.4 is a right to apply for the...
My Lord, yes, I was just seeing how whether the principle that he contends for can be controlled in a way that says, no, it's okay, you don't have to worry about it. It's only because this section 1.4 is cast in terms of an entitlement. It uses the formula. So you don't have to worry about it if and as long as you can point to other things in the regulations that I know my lady was keen to look at. If you can cast it as being not a right further down the line, but some form of discretionary grant of benefit or something, then it's all very different. So I can contain it in that way. What I'm really trying to explode is that, and the coherence of that as an operative or effective or coherent mechanism for containing the overbreadth of the principle. Oh, I'm sorry, Lord Stevens.
Well, I was on the same point as my Lady Rose, namely, I perceive you having an entitlement to apply for a discretion, for the exercise of a discretion, and accordingly, just to say it's an entitlement to nationality as opposed to an entitlement to discretion makes very little difference.
I respectfully agree. It's very difficult to see how it could do coherently, because it would turn on the precise substance of what you got if you could afford to pay the fee, which seems incoherent.
At the moment, I haven't looked in detail at all the fees charged in the regulations, but I would assume that each and every one of them would be subject to affordability if that was the appropriate test.
And I think that's the concern. But the difficulty that I'm confronting on his behalf, not really confronting on his behalf at all, but the difficulty that he faces, perhaps is a better way of putting it. I see him smiling.
Well, it would, to give a concrete example, it would be a distinction between Section 1(4) of the British Nationality Act
Yeah,
and Section 3(1)
yeah,
at page 1315, which seems to just confer on the Secretary of State a discretion, if he thinks fit, to cause a minor who makes an application to be registered as a British citizen.
Yeah.
And that, just reading ahead quickly, looks as if it's a sort of freestanding power to confer on someone who has no entitlement to British citizenship, nonetheless a right. So as I understand Mr. Drabble's submissions, that would not be subject to any affordability constraint on the fee that could be imposed for that.
that as I
That
understand
sort
it
of
was.
highlights the distinction that I understood he was drawing.
Yes, that was my understanding too, and it's the coherence of drawing the distinction on that basis which I'm querying. Because it all turns on the nature of the thing that you end up with if you can get through the door. And that just the nature of the distinction has no bearing on you put the same point in a myriad different ways. Has no real bearing on the control. My lords, my ladies, I see the time. I should think I've probably got about half an hour more maximum, might be even less than that. I might need to spend just a little bit of time. I'm not going to delve into any detail on statelessness, but we are concerned about the procedural position in relation to statelessness. You'll have recalled that we didn't deal with it in detail in our case, and I want to explain why. And I wanted to make a couple of very brief submissions on that. But I've got really 3 more short submissions, about a page worth, on this, and then I'll be on to statelessness as the final topic. I would hope to be done by no later than 11, if that helps for your diary planning.
So James, that's very helpful to give that indication. If this is a convenient point at which to adjourn now, I think we should do so. Thank you very much. The court will now adjourn.